Sakshi TV's special immigration show with attorney Bhanu Babu Illindra from BBI Law Group. Please note that Sakshi TV now has 3 immigration shows every week: on Tuesday at 3 p.m. EST with attorney Ms. Sheila Murthy, Wednesday at 5:30 p.m. EST with attorney Ms. Prashanti Reddy in English, and on Friday at 6 p.m. EST with attorney Bhanu Illindra. Please tune in to ask your questions. If you are an immigration attorney and would like to join our special shows, please email usa@sakshi.com or call 866-725-7441. Before we begin the show, please note that the information provided on this show is not a legal advice. Use of content is for general informational purposes only. Sakshi TV or its agents in the USA or our guests on this show are not responsible for use of information as a legal advice. If you need specific legal advice, please contact the attorneys directly. We will also be taking any general immigration questions along with today's topic. Hello Bhanu Garu, welcome to the show.
Hello, Attorney Garu. How are you?
Very well, thank you. I hope you're doing well too, sir.
Yeah, I'm doing good. Thank you.
Sir, so can you please provide us information on your law offices, areas and your expertise? Also your contact details if any of our viewers want to contact you.
Sure, definitely. As you know, my name is Bhanu Illindra. I'm an immigration attorney. I've been practicing immigration law for almost 18 years now in the US. And we do exclusively represent immigration matters. We do all types of immigration matters: employment-based immigration, family-based immigration, investor visa immigration, F1s, J1s. I mean, all types of immigration matters which are generally covered with the audience who are viewing this call. We represent all those types of matters. Our firm name is BBI Law Group PC. I actually founded this firm in 2008. Since then, we represented in thousands and thousands of matters before the USCIS and various other administrative agencies. To know more details about our firm, what we do, what my practice is and everything is, they can visit to my firm website, which is www.bbilawgroup.com. We are located in Herndon, Virginia, 950 Herndon Parkway, Suite 355, Herndon, Virginia 20170, USA. We are basically expanding the services in India also. Now we are trying to, we will be able to assist people in India who are applying for their visas at the consulates with their application fillings like DS-160s and other things, and reviewing their forms, their documents and everything, making sure that those are enough for their visa approvals are not at the consulates in India. We are providing those services also in India. If anybody needs those services, feel free to reach us. We are very happy to help them with such kind of services as well. If you want to reach our office number is 703-496-7722, or my email ID is bhanu@bbilawgroup.com, or you can also reach at contact@bbilawgroup.com, and we'll be very happy to provide whatever assistance you all need with your immigration needs. Thank you.
Right. So, Bhanu Garu, today's topic is Fdns audits and site visits for employment, do's and don'ts, guidance for employees and employers. And so we will continue the knowledge session this week along with the news and updates on latest immigration, followed by Q&A. But before we get into the topic, you can call us on the numbers on the screen for questions related to immigration and also ask tips. So Bhanu Garu, before we jumpstart with the topic, do we have any updates on immigration this week?
Only I want to give two updates. One is very important one, because many of our people who are from India staying in this country pursuant to their H-1B status and also pursuant to their adjustment of status applications to become a permanent resident in the United States. For them, it's very important to know that in order to file adjustment of status application or in order to become a permanent resident, they have to submit their medical records to the USCIS. Usually, the requirement is that those medical certificates are valid only up to 60 days prior to the submission of those documents to the USCIS. Therefore, if anybody wants to file their adjustment of status application, they have to make sure that those medicals are not done at least not more than 60 days from the date they're filing their 485 application. Now, because of this pandemic and everything, USCIS temporarily waived that 60-day requirement. It said that it does not matter when you have taken the medicals, as long as the medicals has been taken, you can submit those medicals with your application for adjustment of status, that is with Form I-485, to the USCIS, as long as the medicals are done properly and they're in the sealed envelope issued by the surgeon who's actually prescribed by the USCIS, and that should be good enough for them to meet the requirement. So that's a very good news. This requirement of 60-day rule requirement has been waived until September 30, 2022, which is very good news. They have for 1 year now, almost 1 year for that rule waiver. We will see how it goes after that. That's a very important update for the I-485 applicants, especially the people who are trying to file for adjustment of status in the United States. Second update about the travel requirements for the people who are coming to the US from India. It's important for them, they get the RT-PCR test done within 24 hours coming to the US. Previously it was 72 hours, but now they require RT-PCR tests to be conducted within 24 hours. Along with them, they have to provide a proof that they are fully vaccinated. Hello?
Right. So, Bhanu Garu, I think these two updates are good news pretty much, and RT-PCR reducing it from 72 to 24 is still for the national safety, in the interest of national safety. So I'm hoping that these are good news for everybody, for all our viewers. So jump starting with our topic, Bhanu Garu, could you please tell us what an FDNS is and what is its purpose?
FDNS is basically it's an acronym for the Fraud Detection and National Security Directorate. It is a branch or a unit which is a part of the USCIS responsible to conduct audits or to make sure that to detect or safeguard the integrity of immigration laws, protect American workers, and safeguard the homeland. What I mean to say is basically is that they're basically responsible to make sure to put forth the measures to detect fraud and misrepresentation in seeking immigration benefits to the USCIS. That means if people are anything lying or providing any fraudulent information to the USCIS to seek an immigration benefit so that they can migrate to the US. So FDNS major responsibility is that, it's called Fraud Detection National Security Directorate, which is a part or it's called a unit or a branch in the part of the USCIS.
Right. So what kind of audits or site visits can they perform?
Basically, FDNS is conducting usually two types of site visits these days. One is actually they established a program in 2009. They made the changes to the form I-129 also for the cases for that purpose. Basically, before talking to that, I would like to talk to you exactly what kind of applications or petitions for which the people are seeking benefits can be audited or conducted site visits by the FDNS. The main thing is there are majorly four types of cases for which FDNS can conduct audits or site visits. They follow under their ambit to make sure that there is no fraud or any misrepresentation is happening while filing those petitions or applications. One is basically for the religious petitions, basically, like religious worker visas, religious green card, I-360s, all those things. They can do the site visits, Right. And the second one is H-1B non-immigrant temporary visas, basically, And for any employer who is actually filing H-1B non-immigrant temporary worker visa petition, and that they're basically stating on the form and giving a voluntary acceptance, saying that FDNS as an authority coordinate the site visit anytime they want to, for the purpose of verifying compliance or any other issues, basically, And also other type of petitions are L1 petitions. People who are filing an L1s, they can actually can be verified, can be performed. And the fourth type is the EB5 immigrant visa, investor visa petitions. And there are timelines when they usually conduct these site visits also for this type of petitions, right? For special immigrant religious workers, which is basically for the priest and other things like temple priest or any other religious worker in the places like temple, church, or masjid or anything like that. For that, they usually conduct these FDNS site visits, which is basically called ASVVP program, which is administrative site site visit verification program. In short form, we call it as ASVVP program. For that, they can do it before or after adjudication of the special immigrant religious petitions, basically. For the H1B, usually it depends upon what kind of a site visits. We will talk about that also later on. For them, usually after adjudication, and for L1 non-immigrant visas also after adjudication. Whereas for the immigrant investor visas, usually it happens before adjudication. Now, as given this introduction, now I'm going to go to your question, Tharini. Basically, what kind of site visits can happen, right? Basically,
Right.
what types of site visits are there? What kind of programs are there by the FDNS? See, as I said, FDNS actually established a compliance review site visit program, which is called Administrative Site Visit and Verification Program. In short form, we call it as ASVVP. That program was established in 2009. The purpose of the program is making sure that the information provided by the USCIS to the USCIS for seeking a benefit, to verify that information is true and correct, and also to be in compliance. So the employer is in compliance with the information that has been provided in the petition. The same thing with the I'm sorry. Same thing with the employees as well. Whether they're in compliance with the information provided in the H1B petition or L1 petition or any one of those type of petitions which I just stated earlier. So those are the things. Usually that is called Administrative Site Visit Verification Program. This is a voluntary participation program. What I mean to say is, it is not necessary that employers has to participate in this site visit. If the USCIS wants to come and verify under the ASVVP program, and if they ask you to provide such an information, it's not necessary that you have to comply with it, you have to provide with it. But it's always encouraged to provide the information what officers are asking, so that they can complete the review process and make sure that there is no negative information is provided against your company and everything. But they can decline that because it's a purely voluntary participation as per the USCIS regulations. And usually these visits happen, especially for the H1B employment, because most of the times we see these site visits, especially for our communities, it's in the H1B program and L1 program. It happens after adjudication of the petition. Basically, once the H1B petition has been filed by the employer, the petition has been approved, and the employer started working with them or employer not working with them, then the USCIS officer, FDNS officer basically will visit the employer location randomly. They don't have to give you any notification when they're coming and everything. They can visit randomly also, or they can call you, or they can send an email. There are three methods in which they can contact you basically. And they will come and ask you the employer about the premises, where he's working, job duties, etc., etc., etc. All those questions will come in that ambit. What is the purpose of the review is? They can reach the employer, they can reach the employee, and also they can reach the third-party company if the employee is providing services to a third-party company. Usually that happens in the IT consulting business or healthcare consulting business, and those circumstances can come over there. Other type of site visit program, which has been implemented by the USCIS in 2017, which is called, based upon the Hire American, Buy American memo issued by the then President Donald Trump. And that program is basically a targeted site visit and verification program. This is a very this program is what actually is more mandatory thing, basically, because this program actually authorizes the FDNS officers to conduct site visits anytime, on or before. That means they don't have to wait until the case is adjudicated. They can actually come and conduct the site visit even before the case is adjudicated. But how targeted site visit verification program audits or site visit happens is that if based upon the tips given by the USCIS adjudicators or the Department of State officials to the USCIS, to the FDNS, if they suspect of any fraud or any misrepresentation in the documents provided to them, then the USCIS officer, the adjudicator who's actually adjudicating your case, can actually tip the FDNS. Same thing with the Department of State official also. Before issuing the visa, they can actually tip that to the FDNS officer, and the FDNS actually can conduct targeted site visit and verification basically, but to make sure that there was no fraud or misrepresentation by the employer. This can happen before or after, and this is more important, more complex one. This is where employer has to be very careful if the officer comes under this program to verify or conduct a site visit. Even in this also, I think it's not mandatory for you to comply, but it's always encouraged to comply, and that's what it is very important. So, as I said, most of the times these days, the FDNS site visits are happening or based upon the TSVVP, that is targeted site verification, targeted site visit and verification program basis, not on the ASVVP process. Basically, because ASVVP is basically only meant to check compliance by the H-1B regulations, and the USA targeted FDNS officer has to make a report whether the employer is in compliance or not, and provide that information to the adjudicating officers in the USCIS, and they will make a decision whether refer to that case to the Immigration Customs Enforcement responsible to verify any fraud or any misrepresentation in the petitions, or to go against or conduct any investigation against the employer or anything like that. So that's where it's very, very important. When the targeted site visit, especially if you get an inquiry from the Department of State official saying that we are the Department of State official and we are basically contacting you to verify whether this particular individual has a job with you or not, that is basically based upon the targeted site visit and verification program, and you have to understand that. Right. So these are the two types of audits and site visits can happen, Torni Garu.
Right. So, but what authority does the FDNS have to conduct site visits like this?
The authority has given in the regulations that are changed in 2009 and in 2017, basically. Okay, and the regulations clearly tells you that the statute, even INA, actually given the authority for them to verify the compliance issues of the programs for which someone is seeking the benefit. And other thing is, when you're seeking this benefit, actually you are actually giving an authority for the USCIS FDNS to conduct these audits. You are actually waiving your right to privacy by signing on the form I-129 if it's an H-1B visa or L-1 visa program, and then letting the officer know that they can actually conduct and verify whether the information provided them is true and correct or not. Because you have to understand this, the immigration benefits which we are seeking, usually immigration processes, the applications which we file with the USCIS is more of a self-attestation process basis. That means if I'm seeking a benefit from the USCIS, I'm telling to the USCIS that I'm trying to apply for this particular benefit because I'm eligible for that, and I'm in need of that position for that requirement also. For example, I'm an employer and I'm hiring an ex-employee and I want to file an H-1B petition on behalf of ex-employee. I'm telling to the USCIS that I'm an employer and my nature of business is this, and I have a requirement to hire somebody in a specialty occupation, and I'm hiring this person because there's a shortage of US workers, and this is the individual whom I'm hiring and everything, and that's where the whole thing comes basically,
right.
And so that's where, and then I'm telling that the individual also is qualified, but in order to seek that benefit, I and the individual who's my beneficiary, who's an employee, prospective employee, we are providing certain information to the USCIS, and we're giving an authority or authorization to that USCIS saying that they can actually conduct a verification process. They can do the verification that whether the information provided is correct or not. That is where the authority comes from them.
Right. So, Bhanu Garu, we have a caller on hold, Mr. Harish from California. Thank you for calling, Harish. You may ask Mr. Bhanu your question directly.
Hello. Hi, Bhanu Garu.
Hi, how are you?
Hello. Yeah, I'm doing good.
Yes, sir. I'm able to hear you.
My question is, I'm currently in California, but my project is in Texas. And due to the COVID, I was in California for some time, and so my license was expired. So I have renewed in California because my wife stays in California, and I'm traveling to Texas every 2 weeks. I'll stay in Texas for 2 weeks, and I'm just going back to California. So if there's any site visit, do you think I have to notify my employer or anything, or?
you are required to notify your employer because you are maintaining residence in California, not in Texas. I do not know how the H-1B petition has been filed for you and what is the work location stated in LCA and in the H-1B petition for which your employer filed. If they show that, if they file for the Texas work location and also showing that you're going to work in Texas, then you are not in compliance with the H-1B regulations, and also your employer is not in H-1B regulations, as there is a material change, you moving to California, and you're required to file an amendment to the H-1B petition accordingly prior to the moving to California. If you don't do that, then you both are in violation of the H-1B regulations. That means you both are not in compliance. Tomorrow, if any site visit happens, that will actually cause a problem to you, and especially in your situation, you actually changed your driver's license, you renewed your driver's license in California. That means they have an information that can be tracked that you are residing in California, not in Texas, So, and also you're required to file AR11 form also if you move your residence to somewhere else, if any application or petition is pending with the USCIS at that time, And so, I'm sorry. Those are the two things which you have to understand. I think it's better to talk to your employer and ensure that your employer take all the steps required to get in compliance with the H-1B regulations, because it's better for you and your employer as well. Otherwise, what happens is, if the USCIS come to know that the both are not in compliance with the H-1B regulations, then they will issue a notice of intent to revoke for your H-1B and will provide you 30 days time to respond to it, why they should not revoke your H-1B petition. So, and if you can't justify yourself the reasons why you are not in compliance with regulations. Yes.
Sir, I only go 3 days every 2 weeks in California, sir, because I fly on maybe every Thursday or Friday, and I'll be there till Monday, and Monday I'll go back to Texas, and I'll be working 2 weeks in Texas, and again every alternate Thursdays or Wednesdays I'll fly to California, and I'll work in California only like maximum 4 days a month.
Still, even if you work 4 days in a month, if you calculate for 12 months, it's 48 days. That's more than 30 days. Because it's more than 30 days, then your employer required to file an amendment. Okay? If you're traveling less than 30 days a year, then your employer is not required to file an amendment, because they can show that your travel is temporary, not for permanent basis. But here, in your situation, it's not only you're traveling more than 30 days in a year, but also you actually established your residence in California by taking your driver's license and everything over there. So you have to provide the proofs to the USCIS that you're committing every week to Texas, wherever the location is in Texas, and show that you're actually providing services in Texas itself. I think you have a very hard time to prove with the facts what you are telling me.
Right. So thank you for calling, Harish. I hope that helped you. And if you need a private consultation, you can always reach out to Mr. Bhanu. So Bhanu garu, you were telling us about the site visits and what authority the FDNS has. Right.
I think we already discussed
yeah. So, but depending on the previous caller that we just got, is it a good idea to cooperate with this, to meet or respond to these site visits? And
it's a good idea to cooperate, Thorini garu, but how far you're going to cooperate? Basically, exactly what is the information they're looking into? If the inquiry of the FDNS officers or within the pertaining to the H-1B petition what you file, or L1 petition what you file, or pertaining to the benefit what you are seeking with the USCIS, then it's understandable you're cooperating to that level. But if they're asking beyond that information, then you have a right to decline that, because that's, as I said, it's a voluntary participation. Cooperation is always a better idea, but you can always exercise your right not to cooperate or not to participate because it's a voluntary participation, especially if it's an ASVVP site visit. What I mean to say is, if it's an administrative site visit, verification program based site visit, then it's completely voluntary. If it's a TSVVP, then they require you to comply, they require you to provide information, but at the time also you can decline what information to be provided, what information not to be provided. If they want information from you more than that, let them obtain a subpoena, because they have to obtain subpoena anytime if any government agency seeking any information from any individual. So, for example, we are getting, this is not related to this particular call or this subject. We hear a lot of fraud calls coming on the telephone saying that you have been filed a case against you, or IRS has filed a lien against you, all these things. Usually government agencies cannot call like that, cannot tell you like that. In order to do those things, basically they cannot get a lien against you unless they issue a subpoena, get the information from you, and without notifying you, they cannot get a lien on your accounts or anything like that by IRS. Okay? They have to notify you. Usually that notification happens through the letters, mails, and everything. So that's the way it happens, right? So it all depends upon what is the information the officer actually looking into. For example, today, one of the individuals actually talked about certain issues which are basically not related to the H1B petition, what they filed for. And they respectfully declined to provide that information. Then the site visit officer actually had to issue a subpoena to request certain information from that company. So it's very important for you to understand how to do, what not to do, and everything. Of course, there are certain complaints procedures to be laid down in the company where if you're filing petitions to seek immigration benefits, and it's better to have that complaints procedures in the company, and also make sure that who's actually is authorized to talk, who's not authorized to talk to this site visit officers and everything. And that's very, very important,
Right. So I think it's important to know how much that you can comply with and where to stop, or where it's, crossing a line. I think that's where you have to exercise your right for it, right? Okay, so Bhanu garu, we're moving towards the last question for the segment. What kind of typical information do they ask? Like, are there any sample questions probably that these people ask on site visits?
Yes, they can. I mean, there are a lot of sample questions I can provide, and what kind of information they can ask, as I said, is that they can actually ask pertaining to the benefit what you are seeking with the USCIS, right? For example, if you're filing an H1B petition for an employer and employee, then the officer actually can ask any question pertaining to that petition. Like, for example, for who is the beneficiary? What is the beneficiary name? What are the education qualifications of the beneficiary? They can ask what is the name of the petitioner, and who's authorized to sign on behalf of the petitioner, and how many employees does the petitioner have, and what is the position for which they're filing, what are the job duties, what is the salary for the position which you're hiring, how many employees did you have hired or employed in this position. These are the sample questions which I'm talking about, especially if the guy is going to work at the third-party client side. Who is the end client? Who is the representative in the end client? What are his job duties over there? Whom he reports to? These are the questions that are pertaining to and related to the petition itself.
Right.
Those kind of the questions which they can ask into, they can look into.
Right. So it's pretty much situation based and case based. So, right. So with that, Bhanu garu, we come to the end of the show, and as always, it's a privilege hosting you. And I hope our viewers are taking notes from the insightful information you're giving us. And you can always reach out to Mr. Bhanu for a private consultation. So thank you, Bhanu garu, for being on the show.
No, it's my pleasure, ma'am, and very happy. I'm always thankful to Sakshi TV, and especially you, Tarni garu. You are a wonderful host.
My pleasure, sir.
And everybody in the Sakshi team, really thank you for giving me this opportunity.
Humble welcome, sir. So thank you so much. You're watching Sakshi TV Live with me, Torini Makana. Thank you.